Swayam Prabha. Digital India. Educated India.
Dear viewers, I welcome you all on lecture number 9 on the subject of interpretation of statutes. Today, we will be discussing on the topic of interpretation of statutes in consonance with the fundamental rights. My name is Dr. Ajay Sonamne, Assistant Professor, Faculty of Law, University of Delhi. Before we begin with the lecture, let us try to understand what is the topics that we are going to cover today in this lecture. So, today we are going to discuss first what is the concept of fundamental rights. First, we will discuss what is the concept of fundamental rights. Then, fundamental rights in India, how they have been classified, what is the judicial opinions regarding that about the court, and how the court has interpreted the fundamental rights in its Indian context, and we will learn that with help of certain landmark judicial decisions. So, to begin with, first, what is the concept of fundamental rights? Now, the concept of fundamental rights or the topic of fundamental rights, which is enshrined in the Constitution of India in the part 3 of the Constitution. So, it is, as title suggests, the rights which are very fundamental, which are very basic, which are very natural. So, here if you see the evolution or the background or historical aspect of this particular right that can begin from the moment the human being came into existence. The moment human being came into existence, from that moment they possess or they are having these basic rights, which is now we call it as a human rights or the fundamental rights. So, therefore, the natural law theory, which was initially began with on the basis of theory of morality and on the basis of theory of, you can say, or the principle that is based on certain natural principle. So, the natural law theory is the basically founding on two important principles, that is, one is the universal order governing all man, and second one is the inalienable rights of the individual. So, this two principle basically denotes that the law which is prescribed or which is there in the nature, that basically abides all the individuals, because at the outset when the state or the society was not in a proper shape or it was not in existence at all, then individuals who used to believe on the law that is set by the nature, and with the help of that law they believe that what are the moral principles, what are the principles that are existence in the society from immemorial time. So, that became a part and parcel of their daily rule of conduct or daily rule of behavior. So, while this natural law theory was in development, or you can say was in a stage, at the same time this natural rights theory that was developed. So, under the natural rights theory, which generally we call it as both the theories that emerge together, because ultimately natural rights are nothing but the fundamental rights that we have today. And here there are several observations that is made by the several different thinkers, such as thinkers from the natural law jurisprudence or natural law school, or thinkers from sociological school, or thinkers from positivist school. They all have given their observation pertaining to the basic rights or the individual rights of an individual. So, here if you see the first observation that is laid down by Professor Roscoe Pound, and which is very relevant even in today's context and may be relevant in every generation or every future cases. So, Professor Roscoe Pound, who is one of the pioneer of the social engineering theory, he has said very correct or very good observation that interests are nothing but rights, or rights are nothing but an interest which needs to be recognized, protected and enforced by the law. So, here if we just read this definition or this term very carefully, it shows that the rights whatever we have are nothing but a parcel of an interest. So, interest or desire or claim are nothing but the rights that one person has. What is important and what we generally follow even today is that we recognize those interests, we recognize those desires, we recognize those claims, and once we recognize them, then we convert or we try to make sure that we shall protect them. How to protect that? That protection will be possible with the help of enforcement, that is by the law. So, therefore, this process, however, is written by the Roscoe Pound long back, but still that process assumes a great importance in pragmatic sense even in today's. Therefore, every fundamental right that we see have today was because of the Constitution of India, of that these in existence, the Constitution of legislature, or you can say for that matter through their interpretation or the interpretation of the Constitution, they have recognized those fundamental rights, those basic rights which were in existence in the society, and now they have become the part of the law through their judgments or even by the Constitution of India under the part 3 of the Constitution. Further, this notion of rights, or especially the fundamental rights, it carries certain different nomenclature also, that is, they may be called as a birthright, may be called as an inherent right, may be called as a natural right, maybe it can be called as a human rights, so or even essential rights. So these rights are something which is natural, basic, human. The nomenclature will remain same, or the meaning that is given to these rights will also remain same, but only when it comes to its applicability, that is at the domestic level or at the international level, there will be few changes, or you can say few different perspective will be there. But apart from that, every individual possesses these basic fundamental rights, and it is the state or it is the organs of the government, they will strive to protect those fundamental rights. Then next we have is the another observation that is given by Locke, and wherein he has mentioned that a man is born with a title to perfect freedom and an uncontrolled enjoyment of all rights and privileges of law of nature, and by nature a power to preserve his property, which is nothing but his life, liberty, estate, against the injuries and attempts of other men, right? So according to Locke, who is again renowned thinker of the jurisprudence or of the law, so he has also opined that the moment man born with a title, then he has a perfect freedom and uncontrolled enjoyment of all rights and privileges. So there is no control as such, there is no any restriction as such to whether to exercise fundamental right or not. He has that privilege, he has that complete freedom that is given by law of nature itself, and further by nature a power to preserve his property, which is nothing but life, liberty, estate. So again he has that right to preserve those natural rights which are with him from the moment he took the birth. So he can preserve those rights either which is in nature of life, liberty, estate, against the injuries and attempts of other man. So it is ultimately rights are not only the in existence or that can be helpful to live a person with a happy life, but also it is a duty that is important. So other person, if he is not giving the scope to enjoy the rights to the another person, then again that will be difficult. So therefore rights and duties both go hand in hand, and therefore if one person has a right, then at the same time that person has a duty also to respect the rights of another. Moving ahead, when we talk about now enforcement of fundamental rights, then obviously enforcement of fundamental rights saves the individual from the oppression and justice. So here when we talk about enforcement of fundamental rights, when he saves the individual from oppression and injustices, so here the fundamental rights are definitely are now recognized and part of the Constitution of India under the part 3 of the Constitution, but obviously it is the duty of the state that state will guarantee those rights, because if you read the wordings of the Constitution very carefully, then you will find out that the wordings of part 3 of the Constitution, wherein it has nowhere stated that the state has provided or state has given this fundamental right. It simply says that state guarantees those rights. Therefore these rights were already in existence, simply the state is guaranteeing those rights. Further, the recognition of fundamental rights, modern constitutional jurisprudence, because under the modern constitutional jurisprudence the fundamental rights were recognized more in number. You can say it may be such as the right to go abroad, or right to have the clean environment, or you can say right to have a housing, right to have the good food. So these are nothing but the new right which has been recognized by applying the modern jurisprudence or by applying the modern innovative interpretation by the court. So here also we can see that at the international level there is a Universal Declaration of Human Rights 1948, which has also recognized the basic rights or natural rights as a human rights. So therefore even the preamble of the UDHR, if you see, it says that whereas the recognition of the inherent dignity and of equal and inalienable rights of all members of humanity is the foundation of freedom, justice and peace in the world. So therefore recognition of inherent dignity and the equal and inalienable rights of all members of humanity is the basic foundation, right? Then, according to the Supreme Court of India, the applicability of Universal Declaration of Human Rights and the principle may have to be read if need be into the domestic jurisprudence. So UDHR definitely, however, it is the declaration which clearly shows that it is not mandatory to follow, but as a party of this UDHR or as a respectable document, it is an obligation on every state that to respect this document and adhere to the provisions of this UDHR. And even if the requirement is there, even that can be included in the interpretation by the judiciary. Further, there are two now different perspectives, because when we talk about the interpretation of the fundamental rights, then we have to understand the two different perspectives. That is, one in the pre-independence era and one after the post-independence era. So, if you see the pre-independence era, then definitely the position of the fundamental rights or the position of the basic rights was very in a critical situation, because definitely when the rulers were ruling the Indian territory, and again we have to regain our independence which we had lost, then during that period, then definitely many people have become vulnerable, many people could not able to exercise their basic rights in a proper manner. So prior to independence, the need or requirement of the recognition of fundamental right was more, and also definitely the protection was also necessary. But after the post independence era, definitely to get the situation to the normal level, then again fundamental rights, its recognition, its interpretation was important. But however, the aim was more after the independence, because it is the welfare of all, it is the collectivism approach, wherein the constitution itself under article 38 of the constitution, which gives the direction to the state or which gives the guidelines to the state to welfare of the all. So therefore, after post independence, the aim towards recognition, protection and enforcement of fundamental rights by the framers of the constitution. So therefore, these rights were definitely after independence got more, you can say, application, recognition and importance. And one thing that we have to remember is that however these rights may be basic, may be natural, but these rights are not absolute right. These rights are somewhere restricted or somewhere having certain reasonable restriction. So for example, if like one individual has a right to speak, then it is the duty of another person to listen when that person has a right to speak. But at the same time, another person has a duty to listen. That means it is the right and duty combination. But if the another person also has a certain limitation that to what extent he can listen, because beyond that, if you mandatorily push him to listen, then that person is exercising the right in a wrong manner, that is right to speak. Therefore, it is not an absolute right. It is a right with certain reasonable restriction, that the moment till the time you have a right to speak, you have a right to speak. Then another important aspect is that the balance has to be maintained between individual liberty and the social control. So similarly, if you see the social engineering theory, wherein the Roscoe Pound has talked about the balancing of conflicting interest. So balancing of conflicting interest is nothing but between the three stages, that is one individual interest, one social interest and one is the state interest. So wherein the what interest has to be balanced, which is more important, that one has to remember. So always this tussle that happens between these three interests, that is conflict of interest, and obviously that balance has to be maintained by the state, and in such cases generally the social interest that or the state interest that generally takes a front position. Then we have a certain different aspect of the concept of fundamental right, that is cultural, traditional and religious as well as linguistic groups in India are diversified to such an extent that it was necessary to have recognition of fundamental rights to give to the people a sense of security and confidence, because the fundamental rights are not merely in the category of equality, life, liberty or freedoms of speech and expression. Only to this extent fundamental rights are not only important, but also as India is a diversified country, or in India we have a number of tradition, number of culture, number of languages, number of practices of living, eating food or habit, etc. So to recognize those different culture, different tradition, also there is a need to have a recognition under this fundamental right. So therefore, cultural, traditional, religious or as well as linguistic, these different groups also has been recognized under the category of fundamental rights or under the chapter under the part 3 of the fundamental rights. And however, the Supreme Court also has shown a different judicial creativity of a high order while interpreting the fundamental rights. So here there are two observations of the Supreme Court in regard to the nature of fundamental right, or in regard to the how the fundamental rights assumes the significance and the importance. So in the case of Pathuma versus State of Kerala 1978, the Supreme Court has emphasized that the judicial approach towards fundamental rights should be dynamic rather than static, should be pragmatic rather than pedantic, and should be elastic rather than the rigid. So this dynamic, pragmatic and elastic, or that is nothing but the flexible. So Supreme Court should always have some such approach towards the fundamental right, wherein the Supreme Court shall think from all perspectives, Supreme Court shall take into consideration all different angle while interpreting the fundamental right, and Supreme Court should not have a very narrow approach or very small approach or very conservative approach while interpreting the fundamental rights, because ultimately when we call a right as a fundamental right, then this is a natural right. So no one has a right to restrict or to put certain restriction on this fundamental right. Then again there is another case, Ajay Hasia versus Khalid Mujib, AIR 1981 Supreme Court case, wherein the Justice Bhagwati observed that it must be remembered that fundamental rights are constitutional guarantees given to the people of India and are not merely paper hopes or fleeting promises, and so long as they find a place in the Constitution, they should not be allowed to be emasculated in their application by a narrow and constricted judicial interpretation. So again, Justice Bhagwati, who is again renowned judge who became lifesaver of the several poor or vulnerable class, and he has also opined that a judge should not have a narrow approach, and judge should give the as much as broader interpretation to the fundamental rights, so that not only individual, then also a group of individuals can get the benefit out of it. So let us see now what are the classification of fundamental rights. So there are this Article 12 to Article 35. Basically, Part 3 of the Constitution deals with the fundamental right. So Article 12 is basically deals with the definition of state. Article 13 deals with the definition of law. Article 14 to 18 deals with the right to equality. Article 19 to 22 deals with the right to freedom. Then Article 23-24 deals with the right against exploitation. Article 25-28 deals with the right to freedom of religion. Article 29 and 30 deals with the cultural and educational rights, and Article 32-35 deals with the right to constitutional remedies. Now let us try to understand one by one how these rights that have been defined under the Constitution and how the court has interpreted these particular rights in their judicial pronouncement. So if we start with the first one, that is the definition of state. So Article 12 is basically dedicated or devoted for this definition of the state, because most of the fundamental rights are claimed against the state and its instrumentalities. So therefore it is very important to understand the definition of state which is mentioned under the Constitution of India. So first and foremost, because under the definition of state, definitely the controversy or generally the question that generally arises on the point that what do you mean by other authorities, because the one word which is mentioned under the definition of state, that is other authorities, and what is included in the other authorities, that is the question that several times was raised, and therefore here the Supreme Court basically took a good stand, and Supreme Court basically has given a clear meaning that what do you mean by other authorities, which is enshrined under the Article 12 of the Constitution. So definitely initially it was a great difficulty, that because if the case has been filed against a private institution or against the public institution, then in that case whether that public institution is really come under the definition of state or not, then in that case Supreme Court gave certain guidelines, and Supreme Court played a pivotal role in laying down the test to adjust whether a body is an instrument under the definition of state or not. So whether such instrumentalities, including statutory or non-statutory bodies or certain other autonomous bodies, are included within the Article 12, that is under the definition of state or not. The Supreme Court interpreted the word other authorities with such wide connotation and laid down certain tests. So Supreme Court in the case of Ajay Hasia laid down certain tests that what category of instruments or what category of bodies or what category of government or non-government institutions will come under the definition of state. So this interpretation that was done by the Supreme Court in such a manner that this test becomes very important. So first one is if the entire share capital of the body is held by government, it goes a long way towards indicating that the body is an instrumentality of the government. That is number one. So entire share capital of the body, if it is held by government, then that will again come under the definition of state. Second, where the financial assistance given by the government is so large as to meet the almost entire expenditure of the body, then again it may indicate that the body is impregnated with the governmental character. So this is the financial assistance. Again, first one was the entire share capital. And third comes, it is relevant factor if body enjoys monopoly status which is conferred or protected by the state. Okay, so if there is a body who enjoys the monopoly status, but at the same time that monopoly status should be conferred and protected by the state, because simply having the monopoly status will not survive the purpose. That has to be conferred and protected by the state. Then fourth one, we have existence of deep and pervasive state control may afford an indication that body is a state instrumentality. So having the state control, again that will somewhere consider as the definition of state. Then fifth one, last one, we have if the functions performed by the body are of public importance and closely related to the government function, it is relevant factor to treat the body as an instrumentality of the government. So the functions that is performed by the body are of public importance. So if there is any body who is exercising the function that is of public importance, but that is not only enough, that should be closely related to the government function. Okay, so if some body is, if it is working with government, for the government or along with the government, and that is also of a public importance, then again that body would come under the definition of state, because this inclusive of like some of the non-statutory bodies which have been held to be other authorities under the definition of state. So there are certain examples like the Indian Council of Agriculture Research, the Sainik School Society, the Children's Aid Society, the State Financial Corporation. So these bodies comes under the definition of state. Now moving ahead, we have another article, that is Article 13, which is another important article of the Part 3 of the Constitution that defines what is law, because generally we get the question at the initial stage itself that what do you mean by law, what is the definition of law, then generally we get a random answer, but even the Constitution itself has given the definition that what is inclusive of law and what do we expect from the definition of law. So Article 13 is the most and basic important provision that give a strong support and validation to the fundamental rights and which makes them justiciable. The state shall not make any law which takes away, abridges the rights conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. So here the Article 13, when we talk about the definition of law, then primarily the law that is declared by the parliament or law that is declared by the state legislature or law that is declared by the delegated legislation, that is by the number of administrative authorities, this category of law will fall under the definition of law. And plus, if any law that is made by parliament or you can say by the administrative authority or by the state legislature, if it is in contravention with the Article 13 or for that matter any of the fundamental rights, then such law will be declared by the invalid by the court. So here you can see that law that is made by parliament, state legislature, which and also includes the ordinance that is by the administrative authority, order, bylaw, rule, regulation, notification, custom or usage having the territory of India, having the force of law. So the different type of law, it is not only act or statutes are come under the category of law, but also if it is ordinance, if it is order, if it is bylaw, if it is rule, regulation, notification, custom or usages, even that equally considered as the law. Now if such law becomes inconsistent with the fundamental right, then definitely that law will becomes the invalid. So state shall not make any law which takes away the fundamental rights, and law contravening of fundamental right is to the extent of contravention is the void. So there are certain doctrine like doctrine of severability, doctrine of eclipse that could be applicable in such situation. Then Article 13 of the Constitution of India has entrusted a big role to the court to ensure the protection of fundamental rights by applying necessary rules of interpretation. So necessary rules of interpretation that generally comes when we apply when we interpret the fundamental rights or the law on the touchstone of the fundamental rights. Then doctrines like doctrine of waiver, doctrine of waiver, then doctrine of colorable legislation, doctrine of severability, doctrine of eclipse, then these are certain principles that we generally follow. Also the doctrine of harmonious construction, etc. It is an obligation on the courts to declare the law void if it is inconsistent with the fundamental rights, and doctrine of judicial review will be effectively applicable while declaring a statute constitutional or unconstitutional, because doctrine of judicial review is again very important doctrine. It is one of the feature of our constitution. It is one of the basic structure doctrine, and also that gives the power to the judiciary with their interpretation or within the limits that is defined by the constitution, that if they can declare the law invalid which is enacted by the parliament or by the administrative authority. There is a famous doctrine, that is doctrine of waiver, wherein the one individual cannot give away or take away his own fundamental rights to another. So therefore this Baseshwar Nath versus Income Tax Commissioner was one of the landmark judgment in this regard. Now we come to the next category of right, that is right to equality. So Article 14 to Article 18 basically deals with the right to equality. Now the term equality, we have heard several times that there should be a equal treatment, equal protection before the law. So how this term that is given under the constitution, let us see, and how the court has interpreted or how the court has given the interpretation to this term equality. So the first one we have is the right to equality guarantees equal rights for everyone irrespective of religion, gender, caste, race or place of birth. And this right to equality basically applicable or in consonance with the concept of rule of law, wherein the law is supreme and everyone is equal before the law. So similarly, when we talk about right to equality, then everyone is equal before the law, or everyone will get the equal treatment before the law. So every person is subject to law of the land except like president or the governor, wherein they enjoy certain privileges, they enjoy certain immunity, but rest of the all other category of people will not be immune from the such kind of privileges. So they will be equal before the law for whatever wrong they have been committed. And the equal protection of law is again equal treatment in all circumstances. So like there is a thinker like John Rawls who has talked about theory of justice, or thinker like Dicey who has talked about rule of law, wherein the equal protection has to be given to every individual irrespective of their status, caste, etc. And plus the equal protection of law, that means the law which is supreme at that particular era or at that particular state or society. So everyone should get the equal treatment and also the equal protection. Here there is a renowned thinker or academician or the writer on the subject of the constitution, and Dr. D.D. Basu, who has speaked about the equality in such a manner that the guarantee of equal protection includes absence of any arbitrary discrimination by the laws themselves or in the matter of their administration. So equal protection is not only important in the law, or you can say in the framing of law, but equal protection is important while administering the equality or while administering the law. So when administrative authority, when they have a power which may be the ministerial in nature, which may be discretionary in nature, so either exercising both the power, either ministerial or discretionary, in both the condition they shall exercise power in a clear manner or in such a manner wherein they shall not violate the such right to equality of some individuals. So therefore equal protection includes the absence of any arbitrary discrimination. So if they are claiming any discrimination, if the administrative authority aims for any discrimination, then they shall not discriminate any individual in a arbitrary manner, in a biased manner, or in a manner in which is not accepted by the law. So therefore, but at the same time, if law permits them to discriminate them on some justified grounds or on the ground through which they are going to achieve certain goals that is mentioned by the particular act or by the constitution, then they are allowed to make such discrimination. So therefore, the right to equality, generally when we discuss, it may not be taken in a positive sense, but sometimes it may be taken in a negative sense to achieve some good goals or to achieve some higher goals which is present in the society. So therefore, the classification has to be reasonable, the discrimination has to be reasonable, and therefore while making such classification, while making such discrimination, there is a doctrine that is you can say innovated by the Supreme Court itself while interpreting this term equality, and the doctrine is nothing but doctrine of intelligible differentia. So whenever you make the difference, that difference has to be intelligible, that difference has to be logical, that difference has to be intelligibly qualified or intelligibly that equality has to be such that can achieve a particular goals or that can achieve some ideals of the constitution. Then apart from article 14, we have some more provision under this clubbing of this right to equality, that is from 14 to 18. So article 15 is available only to citizens and further prohibits discrimination by the state to access to shops, public restaurants, hotels and places of public entertainment and use of wells, tanks, roads, etc. It also empowers the state to make any special provision for women and children for advancement of any socially and educationally backward classes or citizens or for the SC, ST. And then we have article 16 that ensures that equal employment opportunity in the government and ensures against discrimination by the state in matters of employment on the basis of caste, religion, race, sex, place of birth. And there is article 17 and 18 that includes the abolition of untouchability as well as prohibits conferring any titles. Now let us see some of the landmark cases in this regard. So there is a very landmark and famous judgment that is delivered by the Supreme Court in the case of E.P. Royappa versus State of Tamil Nadu. So in this particular case, the good thing that we have to remember, or good thing that we have to understand, that the court has defined that how the term equality has to be taken into consideration, how the term equality can be interpreted. So this is one of the landmark case pertaining to the scope of article 14, and the case dealt with arbitrary and malified classification and the concept of abuse of power, because this arbitrary malified classification and concept of abuse of power that generally can be observed during the administrative functions. So when the administrative authority are exercising or discharging their duties or exercising their powers, then there is a possibility that they may tend to exercise the power in such a manner that which may be malified, which may be arbitrary in nature, or which may be abuse of power. So therefore court took its view while deciding this particular case that how equality shall be treated in such situation. So equality is a dynamic concept and it cannot be cribbed, cabined and confined within the traditional or doctrinal limits. So it should have a very dynamic approach. Equality can be understood, you can say, from case to case basis, but at the same time while making such discrimination, while making such classification, then it cannot be cribbed, cabined and confined. Further, from a positivist view, equality is antithetic to arbitrariness, and this equality and arbitrariness are sworn enemies, right? So therefore it is against the arbitrariness. So whenever there is a scope of arbitrariness, or whenever if you see that there is arbitrary action or action that is taken by the authorities which is not according to the rule of equality or rule of law, then definitely there will be a violation of right to equality. So thus any act which is arbitrary constitutes inequality in political logic and constitutional law. So the court held that article 14 and 16 are against the arbitrariness in the state action and ensures the fairness and equality of treatment. Again, there is one more important case that is very famous, that was dealt by the Supreme Court again, that is Air India versus Nargesh Mirza. So in this particular case, the state owned Air India company came up with certain rules, and these rules were such that a retirement of female attendants that listed as per these 3 grounds. So what are the 3 grounds? First, the female attendee who has completed 35 years of the age, or the female attendee who has done a marriage or having the first pregnancy. So in this situation, such female attendants has to retire, and therefore these rules were not applicable to a male. These were only applicable to female. So therefore court in such situation that held that these rules that is prepared by this state owned Air India company are arbitrary in nature or are discriminatory in nature against Article 14 of the Constitution, because these rules are only applicable to females, and every female has a right to work, or has a right to livelihood, or you can say right to earn money, or you can say right to work basically. So here if they are making such discrimination on such ground, then such action would be declared as arbitrary, and even such rules were not considered as the valid according to the part 3 of the Constitution. So when these rules of retirement were checked, then it is obviously violating the Article 13 of the Constitution. That is, if rules are made in contravention with the Article 13 of the Constitution or the fundamental rights of the Constitution, then such can be declared as a invalid. So such category of rules were not valid, and even the court gave the interpretation that this is an arbitrary and discriminatory. Now let us come to the another category of fundamental rights that is again very important, that is right to freedom. So I think freedom, liberty and the choice to express yourself is definitely one of the daily important activity or daily important you can say right that everyone has. But what are the different rights that is associated under Article 19 under the freedom of speech and expression? So let us try to see that. So as a citizen of India, everyone possesses these 6 different freedoms. That is, number 1 is the freedom of speech and expression, number 2 freedom of assembly, number 3 freedom of association, number 4 freedom of movement, number 5 freedom of residence, freedom to residence and settlement, and last one is the freedom of profession, occupation, trade or business. So these are the freedoms that every individual possesses, and all these freedoms are not absolute. Okay, this is not absolute. Why this is not absolute? Because if you see the part 2 itself immediately, that these 6 freedoms are subject to certain reasonable restrictions. So there are certain reasonable restrictions. Okay, and these reasonable restrictions are such as because if anyone is exercising his freedom of speech and expression which creates or threatens the security of the state or friendly relation with the foreign state or any public order or decency or morality or contempt, it creates a contempt of court, defamation or incitement to the offense, then in that case such freedom will be considered as the not right exercise of freedom, and therefore in this case this will be restricted by the law, and in such situation if person exercise the freedom in such a manner or which leads to any of this restriction, then that person may be punished by the law. So therefore in this case there are certain observation that is laid down by the Supreme Court in for this Article 19 of the Constitution, and wherein the first observation, that is by Justice Patanjali Shastri, who observed that freedom of speech and of press lay at the foundation of all democratic organization, for without free political discussion no public education so essential for the proper functioning of the process of government is possible. Again, in the case of Union of India versus Association for Democratic Reforms, one-sided information, disinformation, misinformation and non-information all equally create uninformed citizenry, and which makes democracy a farce. Freedom of speech and expression includes right to impart and receive information, which includes freedom to hold opinions. So here when the individual person has a freedom of speech and expression, so if he has to express, or if one individual has to express something, how he will express without having any correct information? So if information, that is nothing but right to have a information, which is again a statutory right which is enacted by the Parliament through this interpretation of Article 19 itself, wherein the right to know, because once you know something, then and then only you can express about it something. So therefore having the information which is a half information, disinformation, non-information, based on that one individual cannot express his opinion. So therefore in this case the court has opined that merely having such half information, they cannot participate good enough in the public relation or even in the election. Then there is a third case we have, is the Bijoy Emmanuel versus State of Kerala. Again, this is very important case wherein the student who did not sing the national anthem did not commit any offense, as there is no law under which their right of speech and expression can be curtailed. Then we come to the another important right, and that is right to life and personal liberty. Again, this is a very vast right, because why it is vast? It is not vast by the text of the constitution, but it is the vast because of the interpretation that is given by the Supreme Court, by the judiciary, by the renowned councils to this article 21 of the constitution. And therefore this is one of the again very important right under the constitution, and judiciary has given a number of different interpretation or to recognize the different fundamental rights which is present in the society. So here no citizen can be denied his or her life except by the procedure as laid down under the law. So a life or personal liberty can come under the threat, you can say, if there is some procedure that is given by the law. Otherwise there will be no threat to the life. No one can be arrested without being told the grounds for such an arrest. If one is arrested, the person has the right to defend himself or herself by a lawyer of person's choice, and it is also mandatory compulsory for the police to take that person to a nearest magistrate within 20 to 24 hours. So this is just an example that if someone's life is under threat, because life in the sense or personal liberty, that if person is arrested and that arrest is without giving the information to the person, or that arrest is without giving any reasons that why this person is getting arrested, then also that is not correct by the law. So the procedure has to be followed, and plus that person, the moment he get arrested, has to be produced before the magistrate within the 24 hours. The Supreme Court has widened the scope of right to life and personal liberty, and this right to life and personal liberty has been interpreted widely to include several rights such as livelihood, health, education, environment, and all those matter that is contributed to the life and dignity of an individual. Then along with the 21, there is a 22 which also again related with the life and personal liberty, that is preventive detention. So under the ordinary circumstances, a person would be arrested after he or she has reportedly committed some offense. However, there are exceptions to this. Sometimes a person can be arrested simply out of the apprehension that he or she is likely to engage in unlawful activity and thus be imprisoned for some time without following the mentioned procedure. So this is called a preventive detention. So if the government feels that a person can be a threat to a law and order or to the peace and security of the nation, it can detain or arrest such person, because there are certain laws that is passed by the parliament or state legislature which are basically for the purpose of preventive detention. So person may be get arrested just to prevent him to do something wrong, or just to prevent him to do something illegal, or just to stop him to do something illegal which may create a threat to the public order, health or morality. So therefore this preventive detention can be extended only for 3 months, after which such a case is brought before the advisory board for the review. But there is a fear that this provision can be misused, and there is a clear tension between the right to life and personal liberty, because if the preventive detention or if the detention of individual is done and if it is not as per the law, or if it is not as per the subject of law, then in that case that detention will be considered as illegal, and again that will be a, you can say, damage to the personal image of that individual. So here under the article 21 and 22 there are several rights, as I mentioned, that has been recognized by the court. So there is a first judgment which has recognized right to education, that is Mohini Jain versus State of Karnataka, wherein the right to life includes the right to education as a fundamental right. Then similarly Unni Krishnan, again the court fixed the age that the right to education is a fundamental right to the children for the age of 16 to 14 years. And the outcome of these two judgment is nothing but the further law that was passed by the parliament, that is right to have this Free and Compulsory Education Act 2009. Then there was a Satwant Singh versus APO Delhi, wherein the right to go abroad is a fundamental right under article 21. Then there is a Sunil Batra case, wherein the inhuman behavior with the prisoners and convicted person is again violative of article 21. Then there is a Olga Telis versus Bombay Municipal Corporation case, wherein the right to livelihood is included under article 21. Then there is a case like Husainara Khatun versus State of Bihar, wherein the equal justice and free legal aid of an accused person is considered The fundamental right under Article 21, and there is a case Rudal Shah versus State of Bihar that talks about the right to compensation in case of illegal imprisonment, that is again fundamental right of a prisoner. So what we can just see here, the different right we have here: right to education, right of prisoners, right of livelihood, right to have education, then right to go abroad. So these rights are nothing but nowhere mentioned under Article 21 of the Constitution, but it is the court who has interpreted right to life and personal liberty in such a dynamic manner or in such a wider manner that they have included these rights under Article 21 and gave this recognition as a fundamental right, and further now individuals at large scale they can exercise or they can claim these rights under Article 21 as their fundamental right. Now coming to the next category of right, that is right against exploitation. Now this is again very important because mostly in the pre-independence era or after pre-independence era, due to the poverty or due to the poor economic condition, this right against exploitation was necessary to have under the fundamental rights of India, fundamental rights of the Constitution. So it prohibits traffic in human beings, beggar and other similar forms of forced labor, and violation of provision is an offence punishable by law. What is prohibited is the act of compelling a person to offer a free service where he or she is entitled either not to work or receive payment for such work. It also prohibits the employment of children below 14 years of the age in factories, mines and hazardous occupation. It is an absolute prohibition without any exception, and there are certain example or act wherein this is the outcome of Article 23 and 24, that Factories Act, Mines Act or Child Labour Regulation Act. So these are nothing but the outcome of the right against exploitation. And there are certain landmark case again here. There is a first case, that is Sanjit Roy versus State of Rajasthan, wherein the state hired people who were affected by the famine, that is this because of the hunger crisis under the Famine Relief Act, and but these affected people were paid less, even below the minimum wages as mentioned under the act. The court held that it is violative of Article 23 of the Indian Constitution and the state cannot take advantage of such people who are helpless in the name of helping them. Another case that is very famous case, that is People's Union of Democratic Rights versus Union of India, wherein the children were also employed under the construction work in an industrial area. The court held that Article 24, that is children below the age of group of 14 shall not be employed in construction work as it is hazardous to health, safety and also right against exploitation. And again there is MC Mehta versus a state of Tamil Nadu, wherein the PIL was filed for the children working in the firecracker factories. So the court held that it is violative of the right against exploitation. Children shall not be involved in any hazardous activities, and the court ordered the state to make strict guidelines for the protection of children against the exploitation. So these are some of the examples of the right against exploitation. Now coming to the next aspect, that is right to freedom of religion. Now this is again very important because India is again considered as the secular state, wherein it gives the importance to every religion, or also there is no special attention or special like the patronage on any particular religion. Every religion is important, every religion has the equal status amongst all. So therefore, being a secular country, and also in the constitutional the preamble of the constitution, the 42nd constitutional amendment has inserted this word secular in our preamble. Again that highlights that the country holds a secular nature, or the country holds that feature of secular country. So here there are these 4 articles that basically deals with the freedom of religion. That Article 25 deals with the freedom of conscience and free profession, practice and propagation of religion subject to the public order, health and morality. Then freedom to manage religious affairs. Then freedom as to payment of taxes for promotion of any particular religion, and freedom as to attendance at religious instruction or religious worship in certain educational institution. So here there are several again landmark interpretation that is given by the court, that is given by the Supreme Court, and this landmark interpretation, or you can say the innovative interpretation, that again help to protect the fundamental right, that is freedom of religion. So the first case, which is very landmark one, which is deals with the term secularism, that is S.R. Bombay versus Union of India. In this case, it was held that secularism is the basic feature of our Indian constitution. In the case like Raja Birkishore versus State of Orissa, wherein the validity of Jagannath Temple Act 1954 was challenged as it enacted provisions to manage the affairs of Puri temple on the grounds that it is violative of Article 26 of the Constitution. The court held that the act only regulated the secular aspect of Seva Puja, and therefore it is not violative of Article 26 of the Constitution. Then further, there is another case, that is Acharya Jagdish Varnananda versus Commissioner of Police, Calcutta in 1983. The court held that the Anand Marg is not a separate religion but religious denomination, and performance of Tandwa on public streets is not essential practice of Anand Marg. And the last case we have here is the M. Ismail Faruqi versus Union of India, wherein the apex court held that mosque is not an essential practice of Islam and the Muslim can offer namaz anywhere, even in the open. Now these judgments, or the number of judgments that is came under Article 25 to between 28, these judgments nothing but that shows that the religion or the practices of religion or beliefs of individual, it is basically differs from individual to individual. And here the court or the position of court is such that being a secular country, every religion should get the equal respect, equal status. So therefore there is no forcible conversion, because even there is a certain acts that is passed by different state like Orissa, Madhya Pradesh, wherein they have punished this forcible conversion of one religion to the another religion. The next comes, that is cultural and educational rights, which is especially that deals with the certain minority groups which are present in our Indian society or country. So Article 29 stipulates that the state shall not impose upon it any culture other than the community's own culture. A minority community has the right to preserve its culture and religious interest. A minority is a group of people who differ from the majority of the population in terms of their religion, language, ethnicity and other characteristics. And Article 30 basically gives the right to the minority that they can establish their educational institution and also administer that educational institution as per their choice. But while administering that educational institution as per their choice, they have to at least adhere to the guidelines that is given by the either the body that is established by the government which deals with the educational matters. So the state is not to discriminate in granting any aid to such institution on the ground that it is under the management of a particular minority. Full compensation has to be paid if the state seeks to acquire the property of minority educational institution, and these rights belongs to the citizens. So there was a landmark case, that is Ray Kerala Education Bill 1958, wherein the Supreme Court has observed that rights conferred on the religious and linguistic minorities to administer educational institutions of their choice is not an absolute right. This right is not free from regulation. This right to administer does not give a rise to the right of maladministration, because if the minority institution has given that liberty that they can establish the institution and also they can administer their institution with their own choice, so that does not give them a right to act as a maladministration. So they have to follow certain basic fundamental natural principle, natural justice principle, and they are not immune from the review from the court. However, these regulations must satisfy the dual test, which includes that such regulation must be reasonable and should be regulative of the educational character of institution and are conducive in making institution an effective vehicle for education. Then there is a TMA Pai Foundation case, wherein the Supreme Court held that the state government and universities cannot regulate the admission policy of unaided educational institutions run by linguistic and religious minorities, but they can specify academic qualifications for students and make rules and regulations for maintaining academic standards, and the same principle applies to the appointment of teachers and the staff. So you have a right to establish institution, you have a right to have own institution, but that is subject to the rules that is set up by the state, even for the appointment of teachers and even for the education purpose. And the court held that the minority education institution does not lose its minority character simply because it receives the aid from the government. But at the same time, it made clear that they would have to admit non-minority students whose constitutional rights under the Article 29(2) are not to be infringed. Then there is a state of Madras versus Champangam Durai Rajan, wherein an order was passed by the Madras government fixing the proportion of each student that could be admitted into state medical and engineering colleges was challenged, as it is denied admission solely on the basis of religion or caste. It was held to be invalid as it was violating Article 29(2) of the Indian Constitution. Now let us come to the right to constitutional remedies. Now under the right to constitutional remedies, Article 32 to Article 35, that basically guarantees the person to right to move to the Supreme Court directly for the enforcement of his fundamental right. And these rights may be suspended during the emergency under article which is proclaimed under Article 352 of the Constitution. And Dr. B.R. Ambedkar has clearly mentioned that this is the very soul of the Constitution, that is one has to take care. There are 5 types of writs can be issued when it comes to the petition can be filed under Article 32. That is, 1 is the habeas corpus, 2nd is the mandamus, 3rd is the prohibition, which is nothing but habeas corpus is to have the body, mandamus that we recommend, prohibition that we forbid, certiorari that to certified or to be informed, and last one, that is quo warranto, is nothing but by what authority or warrant that can be, with the help of the Supreme Court, can issue the several writs. And there are landmark cases which are associated with this Article 32, because Article 32 is the base of this whole Part 3 of the Constitution. So if there is any violation of any of the fundamental rights, then one can approach to the court, that is Supreme Court, under Article 32 for the protection of their fundamental right. So the A.K. Gopalan case, wherein there was a detention, illegal detention was done, and therefore in this case Supreme Court was held that Article 22 was self-contained code, and if a personal liberty is taken away by the state in accordance with the procedure established by law, and if the detention was as per the procedure established by law, then it cannot be said that law is violative. So this detention was not declared as the invalid. Then there is a Maneka Gandhi versus Union of India case, wherein the right to go abroad considered was the part of personal liberty, and confiscating the passport was not as per the procedure established by law, but it has to be in the procedure established by law. So therefore the procedure prescribed by the law has to be fair, just, reasonable, not fanciful, oppressive and arbitrary. Again, in the case of Vishaka versus State of Rajasthan, court has reported that in the absence of enacted law to provide for effective enforcement the basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly against the sexual harassment at workplace, guidelines and norms were introduced by the court, and that basically help for further years, which were considered as the law as per the Article 141 of the Constitution. Similarly, MC Mehta case that brought the principle of absolute liability because of the enhancing the scope of Article 32, and that rejected basically the old principle that is delivered by the strict liability. So in the conclusion, I would like to state that the concept and the philosophy of fundamental rights, that is a dynamic, and it will keep growing, it will keep enhancing as per the need and time of the society. Further, the classification of fundamental rights that we have seen from Article 12 to Article 35, that basically give us the brief idea that which are the rights that we have as per the Constitution, and further how the court or judiciary has interpreted these fundamental rights to such a dynamic and wider sense, wherein this can be a useful for the several individual who will enjoy their benefits or their rights which are already present in the society. So the recognition, protection and enforcement of these rights is basically very important. So with this I conclude my lecture, and I thank you all of you for listening to this lecture. So thank you.